Hi everybody, welcome back to our Facebook Live. This week we're going to talk about is employee absenteeism, leavism and presenteeism affecting your productivity. Brianna, over to you to introduce our guest.
Yes, so I'd like to introduce Stephen Eckert. Stephen is partner and head of employment at Meeby & Co. And Stephen, I think it's best I leave over to you to introduce yourself and your background, because I think you'll do a much more better job than myself.
Thank you, Rehana. Yes, I'm head of employment and a partner here at Meeby & Co. We are a full-service law firm, and we have 5 offices, one in Soho, central London, Camberwell, also Dorking in Surrey, and Chigwell and Loughton in Essex. As I say, we're a full-service law firm. We do property law, litigation, family law, wills and probate, to name a few things. But I head up and practice employment law, and we have a team here at Meeby.
Okay, so thank you for joining us today. And we tend to get a lot of questions from our audience and from our clients, and we thought it would be a good idea to have a topic on leavism, presenteeism, and absenteeism. A lot of isms in there.
A lot of isms, yes.
And I think a lot of questions that they tend to ask is, how do I manage this?
Yeah.
And that's coming from an employer perspective, but I think we need to look at it from an employee perspective as well, in that, you know, I'm ill, but I feel I have to go into work, etc. So I thought we could just leave it broad and have a discussion on that, and give us your input from a legal perspective. First of all, maybe how does an employer deal with it, and then we can look at it from an employee perspective.
Should we explain the terminology first?
Or maybe we can do that. Good idea.
So if we start with absenteeism, that's basically people are off sick, so they're out of the office and absent. Presenteeism, you alluded to, it's very much when somebody probably needs to be off sick, they're not very well, and they actually come into the office for various reasons because they feel they need to, and we can discuss what's driving that behaviour as well. And leavism is a new catchphrase done in the wellness report by the CIPD. Leavism is basically where people are taking holiday, telling everybody they're away, and
they're still in work mode.
Pretty much working to try and catch up because they've got too much to do in the office. So they're actually not taking a break, which is really bad for their health.
So I think from an employer perspective, you can decide how you want to address each one. But from your experience, how can employers manage this?
Well, employers can manage this through a number of mechanisms. The most obvious one, as you, Ray, and I yourself know, is through up-to-date, clear, concise policies and procedures. So it's really important to have an absenteeism procedure combined with a sickness policy, sets out what is acceptable and what employees need to do if they're not feeling very well. I think also it's a good idea to have an open door policy within the organisation, so that any employees who have concerns about their workload, about going on leave, and the status of their work whilst they're away, they can actually discuss this with management and maybe have a handover so that they can go away safely on holiday without having those concerns, and have a true break and a recharge of the batteries that they actually need. I think the problem we all have in this 21st century is that we go on leave. Maybe that we're working from home, or it could be non-work at weekends, but we're always on our phones seeing what emails have come in. We get phone calls as well, text messages from clients. It happens to us all, myself included. I'm always checking my phone when I get up in the morning, even Sunday morning, and there's obviously sometimes work emails, and we tend to deal with it. I was actually talking to a colleague of mine the other day about our experience on leave this year, where he was in New York, I was in Berlin, but every day we were dealing with our work emails along the way, so we don't have this kind of barrage of emails and stuff to do when we get back. So we do it along the way, and I think it's just second nature now. And that's fine to a degree. Some of us can deal with that, but not everyone can. And I don't think that employees should be expected to deal with these things when they're on holiday. And I think, I might be wrong, but I think in France they've actually passed a law making it unlawful to work like that, checking emails whilst you're on holiday. But I think it's all about common sense and finding a correct balance between, just managing your emails and, just working when you could, you may as well be in the office, really. But I think it's important from a wellbeing perspective to have that break, working to regulations, commit employees to having to take 20 days plus bank holidays, paid holidays as well. So from a health and safety perspective, it's really vital and important that employees take that time off, enjoy that time off, and employers encourage non-work during that time.
So the argument I think you sometimes have is that with the bigger organizations, an employer would say, I've got team members that can pick up that work. And as you know, with the smaller companies, it might just be one or two people, sometimes just one person dealing with that. So what advice can you give to employers when they find themselves in a situation like that and the employee has to go on leave, like you said, from a well-being and from a health and safety perspective, they need to take that break?
Yeah, I mean, with a small business, it's much more difficult for employees to kind of disengage themselves from work, where particularly the more senior they are. So I think, from my experience, if you're a senior employee, perhaps in management, it's always good to check in when you need to if something erupts, because obviously you need to be available. But I think also you need to respect the fact that that individual is off on annual leave or maybe absent for another reason. And as I said, it's all about fine balance. I've had examples where not just small organisations, but larger global organisations where individuals at the senior level struggle to take annual leave because they're just constantly busy. They're project leaders, no one else knows what's going on, and they're the point of contact for the client. So they go on holiday, but it's not really a break because they're constantly hassled by clients with emails, having to work around the clock with different time zones. So it's not just the small businesses, larger ones. And from my experience, global, American-owned, Middle Eastern-owned, have that kind of culture and problem. A lot of people work across time zones. So even if they're in the UK and they're not on leave, things come through late at night from America where they have to pick up the phone or deal with emails. So, as I say, it's very important to have policies to deal with these things and make it very clear what is and what is not acceptable. Because at the end of the day, you don't want to be in breach of the working time regulations.
And I think there's a word in there that I think is really important: culture.
Yes.
I think it's really important to recognise, if you're a business owner, that culture is set at the top. And so the behaviour that the senior managers and the CEO and the MD are carrying out is what's going to filter down to the employee level. And so, you really need to be aware that your behaviour is going to dictate how other people behave. And changing that culture is so important to help people understand and be supportive of different ways of being, of different ways of living, and respecting, people have kids, parents, that all the sorts of things that you have to cope with on a day-to-day life, absolutely life. It's something that they really need to have a finger on the pulse on. And I think that's what the wellbeing strategy really starts to dovetail into the conversation that we're having a really strong wellbeing strategy that supports the workplace and drives behaviour as well, I think is so critical. Would you agree?
Absolutely. I'm a strong believer in the work-life balance and have been for a long time. And the law a lot of these things. For example, you know, there's a legal right to statutory holidays, the 20 days plus 8 days bank holidays for a full-time employee. There's legislation to cover time off for family emergencies. For example, there was a breakdown in childcare arrangements. There's also maternity and parental leave legislation as well. And I think the government also wants to bring in some form of bereavement leave, but that's obviously parked given the current legislative timetable. But yeah, there's already things in law to give rights to employees and also workers who need to take time off for such things. And it's all about building these things into your staff handbook, into policies and procedures, and making it absolutely clear that everybody understands what those policies are and that they're adhered to, and that everyone's treated consistently in implementation of those policies, because you don't want to be on the end of a discrimination. So I think at the end of the day, well-being is important, because if an employee is struggling in the workplace because their workload is too much, or because they don't want to delegate, they fear they can't delegate, then a number of things can happen, which will, I think, result in that person burning out or burning up, and ultimately having to go sick. So at the end of the day, that person may not be able to do their job anyway. So I think management need to keep a close eye on individuals who are struggling. That's why it's important to have appraisals in the workplace to monitor not performance, but also how people are. You know, are they coping with the workload? Is anything happening that's causing stress? I mean, stress doesn't have to be work. It could be personal related, and some of these things are private and confidential. But I think an open door policy that I mentioned earlier is always good in the workplace, where individuals who have worries, concerns, and who are struggling have someone they can go to who they trust, where they can offload and get things sorted. Now, there are some employers, unfortunately, that don't take that approach and kind of have a belts and braces way of dealing with things, which just instills and more stress in work. And if all else kind of goes wrong, then there is a legal mechanism where an employee can raise a formal grievance, and it's statutory right to raise such a grievance, and there are forecast codes dealing with how that should proceed. So, you know, if there isn't that kind open door approach in the workplace, then an employee can come back on the grievance, and it's unlawful to victimise someone or dismiss them for asserting that statutory right is a grievance in the workplace. That's why the legislation is there, to protect employees who have misgivings or difficulties with their workplace.
Okay. I just want to come back to something you mentioned earlier on, Stephen. You talked about workers' time regulation.
Yes.
I know some employers don't even know what that is. When they look at an employment contract, they go, what is that? In layman terms, could you explain to our audience what it is?
The working time regulations emanate from Europe. They've been in force in the UK since 1998, I believe. And as I alluded to earlier, it covers statutory annual leave for the first time. It was mandatory that employees have to take annual leave as a health and safety measure. It also covers hours of work, that employees can opt out of working more than 48 hours a week over a period of 17 weeks, something like that. And it also covers rest breaks. Employees are entitled to, well, adults in the workplace are entitled to a minimum of 20 minutes per day to take their lunch. Most employers will allow at least an hour for lunch, and hopefully will pay for that. And it also covers night shift patterns, because there are people who work at night, and there are laws regulating the working shift patterns at night, where medical checks have to be put in place. It's always a good idea for employers to keep a record of the hours that their employees work, so that if there is an audit by a regulatory body, they can show compliance with working time regulations. Many employers do not do checks on hours of work, but I think it's important to do that to protect the employer in case there is a problem, and also to show that they are adhering to things. But yeah, working time regulations are a health and safety measure designed to protect the well-being interests of employees.
Okay, so that dovetails nicely onto the employee side. You mentioned earlier on the one process an employee can decide to go through is a grievance.
That's right.
You know, should they feel that they're being discriminated against in terms of not being able to take the leave, or if they've been off sick, being questioned about that, etc. The one example I used earlier on was that I'm not feeling well, but I feel obligated to go to work, almost to show I'm not well, and then get sent home from there saying, okay, you know, you are not well, go home, go and rest. And it's to be a pattern that happens a lot in organizations these days. What advice do you give to an employee when they find themselves in a situation like that?
As I say, it boils down to the policies and procedures that the employer has in place. From my experience, the larger the organisation, the more comprehensive their policies tend to be, and the better laid out they tend to be. And also, there tends to be contractual sick pay as opposed to bare minimum of statutory sick pay. But that aside, communicating the policy is important. You mentioned those employees that go in where they're really under the weather, but they feel they have to go in. I don't think that's really good for them. If someone's got flu, you don't want to spread it around. So if someone's genuinely sick, then as long as they follow the absence reporting procedures by ringing their line manager by a set time, and just following the process and keeping the employer informed, there shouldn't be a problem. The other issue as well is that many employees, particularly those who need to go sick long term because they develop a condition or an ailment, may be put off going sick because of financial ramifications, because if the employer will only pay statutory sick pay, that in itself creates another pressure. So employees feel they have to go in because they can't afford to go sick, which obviously is wrong as well. So it may be wise for employers to use their discretion and maybe have a discretionary policy in terms of paying full contract pay for a limited period, but making it clear that we're not creating a custom and practice. It's a one-off to accommodate that employee, so that they get well and can return to the workplace as quickly as possible.
Couldn't you then open yourself up potentially to grievance procedures from other employees, where if you have one that gets approved and one that doesn't, couldn't they then complain that they'd been discriminated against or something?
Of course they could. As I said before, it's important to be consistent in the implementation of your policies. What you could do in such a situation is to have a private discussion with the individual to keep the arrangements confidential, and to put it in writing that this is a discretionary policy, it's a one-off, and it's important to keep it completely confidential to enjoy that benefit, and to make it very clear that it's not we're not creating a new policy or a contractual custom practice argument. It's a one-off. We're exercising our discretion. But I think if you can exercise your discretion generally with individual employees, then that's fine. You can always make a difference between those who are genuinely sick and those that maybe are, I think we used to call them lingerers, who go sick often without a real excuse, always coinciding with a sporting event. So I think most employers can tell the difference between genuine sickness, backed up by medical evidence. Someone may develop cancer, or they may need treatment for some condition that they develop, and it's all about supporting that employee and to manage the process, to listen to medical evidence as to what the employee can do and when they can return. Because what you don't want to do is open yourself up to disability discrimination if you dismiss if someone has what we call a disability. So it's very important for employers who are unsure what they're doing to seek timely legal advice.
Yeah, I have to admit, I see a lot of presenteeism from a different perspective, where companies are going through a lot of uncertainty, a lot of change. There's potentially redundancies coming down the line, and people turn up when they're ill because they don't want to be seen to be the person that's taking the time off sick, because they're worried that if there are redundancies, if they've taken a lot of time off, they'll be one of the first to go. I mean, what's the legal perspective on that sort of thing?
Yeah, I mean, if there's genuine redundancies where there's a reduction in the amount of work available, or maybe a downsizing or a restructuring or a relocation, then I mean, what employers need to do is have a proper selection pool for work of a type that is affected. It may be that it's not a standalone post, it's a pool of employees, and there's a selection criteria, selection pool, where the employer has to mark those people that are in that pool. And you know, you can really use sickness or long-term sickness as part of the criteria, because to do so would expose that employer to a potential claim for disability discrimination. Similarly, with maternity, you can't use the fact that someone's been off on maternity as a selection criteria, because that would open you up to a pregnancy or sex discrimination claim. So you've got to keep it, basically factual in terms of performance and skills. Even length of service is a bit of an issue as well, because that could be age discrimination if you use it negatively. So with all these things, any redundancy process based on the employee's skills and experience, you keep the best employee, and you genuinely mark it properly. Now, the employee who is scared to go in because they believe there will be redundancies, and if they're genuinely sick, they shouldn't really struggle to go in, because, as I said before, it could make their condition worse. And if someone is sick and can't do their job, then it's going to be noticed in the workplace.
Yeah.
And then you could get into the arena of performance issues, because someone may cover up the fact that they are sick, but it's affecting their ability to do the job. And then the employer may mistakenly believe that there's a performance issue and may go down the disciplinary route. So by concealing it, it could open up a can of worms, and the truth will come out. But as far as the employer is concerned, it's about minimizing exposure and having that open door policy to have good communication channels. What you don't want is a draconian, toxic place of work with a hostile working environment where everyone's scared to go sick, because that's not good to anyone, and it's certainly not conducive to the employee's health and well-being, or really employer who often spends a lot of time and money on recruiting staff, only to have that terrible culture that results in them leaving and finding other employment, taking all the knowledge about your business away with them to a competitor.
Where would the employer stand though? I mean, say they're doing the round of redundancies. Somebody that might have had quite a lot of time off sick, the chances are they might also be a poor performer as well at that time, not necessarily from a long time, but around the time that they're sick, they might also be a poor performer, because whatever their illness is, whether it's physical or mental, might be impacting their ability to do the job. So when the employer comes to looking at the list of redundancies, they don't label that person as a potential person for redundancy because they've been off sick. They label them for a potential for redundancy because they're now a poor performer. So how does the employer or the employee stand on that side? Would you still have potential for a claim against unfair selection, or?
Yeah, I mean, if there's true transparency in the workplace about these things, then it will be obvious to the employer that the reason for the underperformance or the failure to reach a certain target is because of the sickness that's impacted upon performance. I think you have to kind of split it between, those who are genuinely underperforming, not because they're sick, but they're genuinely underperforming because they're no good at the job, and those that aren't reaching targets or standards because the sickness has got in the way. So if there is genuine communication and transparency, then the employer in a redundancy situation should take that factor into account. And most employers will know from experience of working with those individuals, who are the good ones and who are the bad ones. And if someone is unfortunately sick long term, then obviously that shouldn't be taken into account. But some scrupulous employer may use it as a tool to get rid of someone when really they shouldn't. And by doing that, of course, it opens them up to a claim because we can't stop employees from issuing proceedings. If we go down that route, it's their prerogative. Obviously, the employer will have to deal with it to pieces should they misapply the law, which ends up in a lawsuit. Once you're on that conveyor belt, you can't get off it unless you settle or the employee withdraws the claim, which for most of the case is probably unlikely.
If you've got an employee that is off long-term sick, is there a point as an employer that you can actually ask them to leave the organisation if it's long-term?
If someone's off long-term with an illness that prevents them from returning to the workplace, or it could be that they develop that's terminal, then they can't just dismiss.
No.
That would open them up, the employer up to some form of discrimination. I think disability is a protected characteristic. In addition, for a disability, it has to be 12 months or more, terminal. To be physical or mental impairment impacting on day-to-day activities, the legal jargon and definition. But in layman's terms, if an employer has an employee in that situation, then they again should have good policies and procedures. It would involve referring the individual to occupational health if they're a large organisation. There should be a right for the employer to, with the employee's consent, which cannot be unreasonably refused, to allow consent to access or make contact with their GP or medical specialist with a view to asking questions about the prognosis and the medication being taken and the future. So I always advise the employer that it really is dangerous to dismiss an employee unless they've ticked all the boxes, and that the medical advice is that the employee in question is never now going to be permanently fit to return. So once you've got that in writing, you would then need to have a discussion with the employee to address this issue and ask them whether they can think of anything that can be done to get them back into work. And in that situation, a lot of them will say, well, no, we can't think, I'm just not fit and I'm going to improve, which is obviously a worst case scenario. And then obviously, once you've exhausted what usually is a process, it's not a process, you possibly can dismiss with notice. What some employers do, depending on funds, is that they may enter into an exit arrangement with that employee and effectively give them a financial package backed up by a settlement agreement whereby the employer gets the comfort of knowing that that individual isn't going to come back and sue them because they'll waive their legal rights, including disability discrimination rights. Other employers, larger in size, may have an early retirement option that can be utilised to assist that employee. Other organisations may have what we call some form of income protection policy, where the insurers will pay 70% of salary. I've got a friend who developed ME and couldn't work and is still not working, but the insurers are still paying 70 or 75% of salary. So if you're fortunate enough to have that as a contractual benefit, then you can probably use that. But that's the exception rather than for most of it, unfortunately.
So somebody could end up going off sick long term, and the policy of the company would mean that eventually they might be in a situation where they would still be legally employed by the company but not paid by them. Could that?
That's right. The box standard employer will only have SSP, statutory pay, which is about £94.25 per week at the moment, and it's only payable for 28 weeks. So it's only employees entitled to a hybrid category of workers. So once that 28 weeks is up, there's no further entitlements in that period to further statutory sick pay, unless the employee returns and goes off sick later in another period. But if it's long term, as I say, once that 28 weeks is up, that's it. And then you will have a situation where the employee is still employed, still on your payroll records, but they're not earning anything because there's no sick pay, contractual sick pay entitlement. So I've had situations where the employee's been off sick longer than they've worked, and the employer just hasn't done anything about it. But that's not the advice I would give in that situation. It would be better to bring the employment relationship to an end through medical opinion, whether that individual is permanently fit to return or not, or maybe so if you can afford it, to do the moral thing, enter into some kind of financial arrangement.
Yeah. Otherwise, if the person doesn't take those steps, then otherwise they can't go to social services or wherever to get money. If the employers stop paying them, they've still got to survive, haven't they? So you can.
They have. I mean, if the statutory sick pay runs out, then they can probably access some form of universal credit. I think it's called these days. So I think there's a safety net that they can go to. It's a bit like maternity pay, where you don't qualify for maternity allowance that you can get from the state. There's always a safety net that you can kind of fall back on if you need to. But I agree, it's not ideal to be in that situation, and it would be far better to have policies that deal with what to do in that situation, so that everybody, including the employee, knows, and everybody knows where they stand.
I think you mentioned something quite important, that sometimes employers just ignore it, almost like burying their head in the sand like an ostrich.
Yes.
And I almost think it's because they're overwhelmed with all of this and they don't know where to start, and they feel that they're doing the wrong thing if they're going to sit down with the employee and discuss it. And I think it's almost because they feel they're in a minefield, don't know what to do, and they don't have the guidance. And now, as you know, in smaller organizations, they don't have, let me call it, the luxury of bigger corporates where they got an employment law department to go to, and they've got people that can advise them. So in terms of the small business owners, where would they go to find this advice?
Yeah, you pick up quite important stuff there. Obviously, the larger organisations have in-house resources, budgets to go outside if they need to for the employment law advice. But for the smaller organisations, particularly those that started, they haven't got a clue, and they don't have the luxury of HR or legal professionals like us. So I always say, to any business, whatever size, it's always important to get timely HR and legal advice, because by doing that, you can often nip the problem in the bud, yourself a lot of costs. The situation you mentioned, employers burying their heads in the sand, from my experience, leads to difficulty further down the line, because by ignoring a problem, things will happen where, again, it exposes business to risk of a claim. not maybe by that particular employee, but maybe others that may be affected by the burying in the sand, nothing's done, and any sapping just, you know, through the organisation. So if it doesn't result in a legal claim, it could result in loss of quality staff. So it's important to address these things, and as I say, from my experience, getting timely advice and a strategy in place to deal with those issues is often the best way forward and the most cost effective as well.
And Rihanna, I think you've got a good story to tell where you've actually had to deal with somebody that was taking advantage of the absence sickness policy, I think, weren't they, where you've actually had to go through a process of disciplinary. So you've been on the other side of the fence, where the employer has really been swinging the ledge, so to speak.
Yeah. And I think sometimes as an employer, you try and accommodate as much as where you can. Because I think it comes back to what you were saying, Stephen, is that you want to help the employees, but also promote a culture of where you're looking after the welfare and interest of your employees. But it comes to a point where you also have to say enough is enough. And unfortunately, in that case, you know, we had to then go down the route of let's investigate. How many days were you off sick? And then, like you said, let's get an outsider then to look at this and get medical advice, and then based on that, make a decision of the way forward.
Yes, I mean, from my own experience, I've worked for organisations that have a self-certification scheme. So for the first 3 days, they're treated as self-certified sick days, where you don't need a doctor's certificate until the 7th day. For that, those, you know, if you had the odd sporadic 1 day or 2 days off, you also always had that fear that when you return, HR is going to question you, and you're going to fill in a form by your supervisor, which asks what your symptoms were, why you were off sick, and the date. So that always filled me with dread and kind of put me off going sick. But obviously, if it's genuine, you shouldn't have anything to fear. And I think it's a good way of monitoring those in the organisation who maybe are swinging the ledge, and a pattern emerges, and then you can do something about it. It also is good to monitor sickness, because someone could be genuinely ill. It could raise concerns and lead to discussions where that employee takes medical advice because, you know, there's something wrong with their health and no one knows what it is. We hear a lot about mental health these days. It doesn't have to be a physical matter. It could be mental health that's affected, caused by stress, depression, all manner of things. So it's just not the physical symptoms, it's also how you feel as a person. And some of that stress can be work-related with, you know, the culture that we discussed. Maybe there's a hostile working environment, maybe there's a change of line manager, or maybe they're tightening the screws in terms of performance managing, which is a pressure in itself. So these things can affect mental health. And from my experience, there have been scrupulous employers who deliberately bully employees under the guise of performance management in the hope that they'll run and resign. That's not the way to deal with it, obviously, because those loose cannons are opening up the organisation to the risk of the drain. But you know, I've seen pretty much all of it over the time I've been practicing. Nothing really phases me. And it comes back to the same thing. It's all about good policies and procedures. You can't really make it clearer than that.
Exactly. And I know I'm generalizing now, and I'm probably shocked for this. But you know, you find that the employees who are scared in terms of going off genuinely sick are normally the ones that are genuinely sick.
Yeah.
Those that just take sick days here and there, they are the ones that don't think twice about filling in your self-certification form. Don't think twice about being asked. They do it so casually.
That's right.
Like I said, it's not everyone, but I've experienced that.
Yeah, I mean, I've worked for public sector organisations where, as part of their sickness absence policy, you were allowed maximum number of sick days, say 13 days, 14 days, and the employee incorrectly believes that they're entitled to take those sick days. Oh, I haven't used up all my sick days. Well, it's not an entitlement, it's just the bad drafting of old-fashioned policies which tried to limit the number of days you could be sick, which you can't really do, because if you're sick, you're sick. You shouldn't really have a set number of days in this day and age, because it doesn't work. If you're sick, there should be a policy in place to what you need to do, who you need to contact, how you update people, provide medical advice, and allow your employer access to that medical advice, so that it can accommodate a return to work, so that rather than later or a phased return, depending on the situation.
You wouldn't want to necessarily limit the days that people are allowed to go sick, but I guess you might have a policy in place that says if you're sick for so many days, it will trigger a process whereby we will want to talk to you about what's going on. Because
yes, that's right.
As a safeguard to also protect the employee as well, to make sure that these patterns are being recognised. I mean, you know, mental health's got a big focus at the moment. If it's a mental health problem, if they're suffering from stress, you want the HR department or the manager to spot these trends and start having a conversation with the person to actually see, well, where you at, what's going on, what can we do to help?
Exactly. Yeah, I agree. Yeah, it's important. We keep talking about this clear transparency line of communication. So an open culture in the workplace will push these things out, and any good employer as well. It's the ones that bury their heads in the sand, those that have a poor work environment, which creates the problems in the first place, creates the employee going off sick. They're the ones that are going to kind of end up having issues, I think. So if genuinely sick, it should be treated properly. You know, you can have a procedure where if someone's off sick so many days, you start that process, and by having that discussion at a sickness absence review meeting, you can find out what's going on. You know, if there's a pattern of particular days that off, is it Fridays or Mondays? Is it one day here or there? Is it 3 days? And that's why it's important to monitor sickness absence, to keep a record, not just to keep a check on the employee, but not, you know, it's nothing mischievous here. It's about keeping good records to monitor the health and well-being of that individual responsible for a large part of the working day, and that's that duty of care. So if anything happens, you know, the employee could collapse on your premises. If you've got a record of these things, then it can back it up and assist you in how to deal with it in the future.
Sorry. I think what you've been mentioning over and over again is the policies and procedures. And I think it's critical that companies or even small businesses realize that it's helping them be proactive. And by having that in place, a lot of these issues can be dealt with beforehand, because everybody knows what guidelines are, and also where to go to if they don't know what to do. Yes. And I just find a lot of, especially the small businesses, think, I don't need that. It's fine. We won't get into an issue.
Yeah, that's fine to have that attitude, but as I say, it's all about processes. If you are fortunate to be an employer, then with that comes obligations and responsibilities. And part of that is looking after your staff and making sure that you cover all the eventualities, however large or small you are. And the only way you can do that is by having rules, which we call policies and procedures, which are fair and reasonable. It's not a rule book, it's basically you know, a structure and a process to follow to deal with these things, and which kind of err on the side of the law. The law would expect an employer to implement such practices. So it's for the protection of the business going forward, because if you don't have structure, if you don't follow things within the boundaries of the law, then that will trigger rights that the individuals could have should the employer dramatically wrong, what you don't want is a small business ending up the other side of an employment tribunal claim where they're going to have to shell out, I don't know, 10, 15, 20,000 pounds because they got it wrong. That's a year's salary for someone. That will eat into budgets. It'll prevent pay rises for good quality staff. So, you need to think about these things. And as I said before, getting the timely advice, and legal advice before these things kick off.
I think what you said about the duty of care is a really important one as well, because I think that as part of that, with the mental health side of things, there's a lot that employers can do to support staff to actually reduce absenteeism, presenteeism, leavism,
yes,
by looking at the stresses, by having support available, and actually being proactive about making their environment a better place to work, and looking at how they can help and train employees that doesn't become unmanageable, so that you don't have those high numbers. And when you look at the amount of people that go off sick with mental health and stress and anxiety related issues, I think there is a larger duty of care that all employers need to start looking at, to actually start thinking seriously as part of those policies and procedures. Well, what is our wellbeing strategy, and how does that dovetail into these policies?
Yeah, I used to work in publishing when I was in-house, and they used to have a lady come around every Friday, early afternoon, to do head massages. So there'd be a room where the employee would lay out on a couch and have a head massage. And many people were really impressed with this. It helped them relax, it took away a lot of the stress, and it was positively encouraged by the employer who paid for it. Other employers have other kind of health benefits, for example, subsidised gym membership. They can buy block cover for their staff at attractive rates. They could maybe allow employees to leave early if they want things. Flexible working arrangements are also really important, particularly for those who have children, childcare responsibilities, and don't stop there. When someone is pregnant, goes on maternity, why not share maternity? You can do that now as well. I mean, my take on the flexible working rights is that it's all very the government creating rights. The problem is that the take-up is very low because people can't afford to have their pay related to the statutory payments, particularly if you're the main breadwinner. So, the government really needs to ensure that employers pay, ideally, the contractual rate or something near it, because otherwise, we're not going to see an increase in take-up rates for these benefits and rights that the government have introduced.
Okay. Is there anything else you want to ask?
No, I'm just looking at the time and thinking that we probably need to finish it there.
We could speak all day about it. It's amazing.
It's such a big topic.
And I think what's it's relevant as well, especially in companies these days. If I think back, and giving my age away here, about 15 to 20 years ago, some of these issues we're dealing with was not on this scale. So and I think it's important that we talk about it, because that's the way people learn from each other. But Stephen, I want to thank you so much for taking the time, having a discussion with us this afternoon.
My pleasure.
There's a lot that I think people can gain from the discussion we had.
Yeah. Oh, before I forget, government is intent on updating statutory sick pay in the future. We don't know when, but they want to kind of extend it to not just employee contractors, those in the gig economy, workers, that hybrid category, and to also introduce phased return to work combined with statutory sick pay. But as all things, the devil is in the detail, and it's just a consultation at the moment. But there are updates statutory sick pay, which frankly hasn't been updated for many, many years. Since I've been practicing, it's been the same with the usual April increase in line with the inflation rate. So maybe we'll see some changes to that, which will benefit a wider pool of workers in the future.
Okay. Fingers crossed on that.
Yeah.
Thank you for that information. And as I said, it could be that there will be people that's going to say, I benefit from the discussion. However, I've got more questions. Where do I go to? So before we close off, I'd like to give you an opportunity from your side to let our audience know in terms of how you can assist and how they can contact you.
Well, say if any business or individual has concerns about anything to do with employment law, from recruitment through to dismissal, beyond, and managing the employment relationship, then they need to get in touch with an employment lawyer. And I've got over 25 years experience, so you know, I think I'm best placed. I've seen most things in the employment arena over the years. So please get in touch with me. You can look us up on our website. It's Leavism Co. And as I say, we've got 5 or 6 offices in London and the South East. We're totally accessible. So please do look us up, and if you've got any of those concerns.
And so you've mentioned the employer side now. I'm going to assume employees could also contact you if they've got an issue with the employer.
Employers can, and employees. Yes, we deal with both sides of the coin. In terms of employees, we deal with not just high net individuals, but those on the shop floor as well. Some who've been there many, many years, who are facing difficulties and just need a steer on how to deal with things. A lot of it's legal, it's practical advice, things they may not have thought of. Again, looking at policies and procedures, what does it say? And in terms of communicating with those that need to deal with things. So yeah, we're both employers and employees.
Okay. Thank you so much.
It's been a pleasure. Thank you for inviting me.
And,
Thank you, Stephen.
yeah, and I will put your details in the link below when we post the video. So whoever wants to contact you can contact you via that as well.
That's perfect. Thank you so much.
Bye.
Bye-bye.